it's fine.
Is this interfering, Tyler?
It's a little annoying.
You're getting the screen, right? It's right in front of you?
Yeah.
Okay. That's what I didn't want. Move it back to the side. Better? Okay. Okay. Okay, this is where we left off. If you had a drug problem, would you want to go to prison or a mental hospital? And I got some feedback on that. Most of you prefer a hospital. And of course, if you have a drug addiction, that's probably where you belong. Getting treatment for your substance abuse problem. Our court system, it's an adversarial system. It's a win-lose, and everybody wants to win. It's the government, represented by the prosecution office, versus the defendant, represented by his appointed attorney, most of the time. Accuser versus accused. Remember, in our judicial system, the assumption is, going into court, that you're innocent. You must be proven guilty in a court of law, beyond any reasonable doubt. That's the level of proof. Beyond a reasonable doubt, that's the level of proof in a criminal court. That really means 100% certainty. There's no doubt whatsoever that this person is guilty. They must be proven to where all 12 jurors believe this person is guilty. So what if 11 jurors come back with a guilty verdict, but one says, no, I don't believe he's guilty? Is he still convicted? No. That's exactly what it means. You gotta have all 11. That's called a hung jury. Okay? A lot of times the judge will instruct the jury to go back, deliberate some more, to come back with a unanimous finding. After a couple attempts, if that's not working, the judge has no option but to announce, hey, we're a hung jury, we couldn't get to a decision. A couple of things happen. The district attorney regroups. They have to decide, are we going to refile these charges, or are we just going to let it go away? That's not double jeopardy, because there was no verdict. So the district attorney does have the right to refile charges. When we have a hung jury, the government prosecutor will ask for the judge to poll the jury. They want to know how many of the jurors had reservations. And they do that in open court. So the judge will ask them to announce their verdict. If the verdict was, say, 7-5. 7 in favor of convicting, 5 are hesitant to convict. That's 5. Most likely the government's going to look at it and say, man, we don't have a case here. And they're not going to refile. Most times. But if they come back 11-1, only one person had reservations, most likely they will refile. Because they look at the odds and say, you know, we got a good chance of winning. Let's do it again. Especially if the charges are serious, such as a murder or homicide case. So preponderance of evidence. Preponderance of evidence has no place in a criminal trial. It's up there because that's the level of proof needed in a civil proceeding. 2 different levels of certainty. Reasonable doubt, 100%. So what is preponderance? How much certainty do we need there? Who wants to take a shot at that one? Let's go with Edgar. You look like you're down studying. What do you think? What's the level of certainty?
Like a percentage?
Exactly. Give me a percentage.
At least above 50%.
At least above. That's a heck of a shock you took me. It's exactly what it is. It's just above. It's not 51. Two scales, right? Two scales, equally balanced at 50-50, exactly balanced. Take a grain of sand and put it on one side to tip the scale. That's preponderance. You believe it just more than you don't. And that's why it's not used in criminal proceedings. Got to talk about O.J. Simpson at this point. In the criminal trial, he was not guilty. The glove didn't fit. They had him acquitted. But in civil proceedings, what happened? He was found guilty. He got slammed because of the level of certainty. You follow that? Yeah. Okay. That's a big deal. In criminal court, beyond a reasonable doubt. In the prison systems, in the court, county system, private jails, the level of certainty used for hearings at the administrative level is preponderance. And I heard at least 1,000 cases, probably a lot more than that, but at least 1,000. Preponderance. It's not much. I just believe it a little bit more than not. They're guilty. Questions on this, the level of certainty or the adversarial? Good. You will see those again. Now here's a little, God, I hope, yeah. A little video on adversarial.
The adversarial system or adversary system is a legal system used in the common law countries where two advocates represent their party's case or position before an impartial person or group of people, usually a jury or judge, who attempt to determine the truth and pass judgment accordingly. It is in contrast to the inquisitorial system used in some civil law systems, that is those deriving from Roman law or the Napoleonic Code, where judge investigates the case. The adversarial system is a two-sided structure under which criminal trial courts operate that pits the prosecution against the defense. As an accused is not compelled to give evidence in a criminal adversarial proceeding, they may not be questioned by a prosecutor or judge unless they choose to do so. However, should they decide to testify, they are subject to cross-examination and could be found guilty of perjury. As the election to maintain an accused person's right to silence prevents any examination or cross-examination of that person's position, it follows that the decision of counsel as to what evidence will be called is a crucial tactic in any case in the adversarial system, and hence it might be said that it is a lawyer's manipulation of the truth. Certainly, it requires the skills of counsel on both sides to be fairly equally pitted and subjected to an impartial judge. By contrast, while defendants in most civil law systems can be compelled to give a statement, this statement is not subject to cross-examination by the prosecutor and not given under oath. This allows a defendant to explain his side of the case without being subject to cross-examination by a skilled opposition. However, this is mainly because it is not the prosecutor but the judges who question the defendant. The concept of cross-examination is entirely due to adversarial structure of the common law. Judges in an adversarial system are impartial in ensuring the fair play of due process, or fundamental justice. Such judges decide, often when called upon by counsel rather than of their own motion, what evidence is to be admitted when there is a dispute. Though in some common law jurisdictions judges play more of a role in deciding what evidence to admit into the record or reject. At worst, abusing judicial discretion would actually pave the way to a biased decision, rendering obsolete the judicial process in question, rule of law being illicitly subordinated by rule of man under such discriminating circumstances. The rules of evidence are also developed based upon the system of objections of adversaries, and on what basis it may tend to prejudice the trier of fact, which may be the judge or the jury. In a way, the rules of evidence can function to give a judge limited inquisitorial powers, as the judge may exclude evidence he/she believes is not trustworthy or irrelevant to the legal issue at hand. All evidence must be relevant and not hearsay evidence. Peter Murphy in his Practical Guide to Evidence recounts an instructive example. A frustrated judge in an English adversarial court finally asked a barrister, after witnesses had produced conflicting accounts, single quote, "Am I never to hear the truth?" "No, my lord, merely the evidence," replied counsel. The name adversarial system may be misleading in that it implies it is only within this type of system in which there are opposing prosecution and defense. This is not the case, and both modern adversarial and inquisitorial systems have the powers of the state separated between the prosecutor and the judge, and allow the defendant the right to counsel. Indeed, the European Convention on Human Rights and Fundamental Freedoms in Article 6 requires these features in the legal systems of its signatory states. The right to counsel in criminal trials was initially not accepted in some adversarial systems. It was...
Did you hear a comment? Unless she gets tiring. But did you hear a comment about trying to find the truth? We mentioned that Wednesday. Trying to find the truth. They said, no, we're not interested in the truth. We just want to know what we can prove. Keep that in mind. Only what we can prove. They don't care about the truth. Only what they can prove. Each system, no matter where you go, stakeholders, role players, everyone plays a part. These are just some of the characters in that process. The defendant, prosecutor, defense, attorney, usually a public defender. Pro bono work, what's that mean? Free. Okay, every attorney is required to do X amount of pro bono work by the American Bar Association. And they don't do it just because they're nice. They're required. They have to do X amount. Ombudsman, just a representative. The judge, the jury. To sequester. What are we talking about? What does that mean? Sequester.
Isn't that when you like put the jury like in a, I don't know, like hotel?
Yeah. We put the jury in a hotel. You separate them from all outside influence, contact. I think OJ's trial, the jury was sequestered. Pretty sure they were. And that trial lasted for quite a while. So it can be a real burden on the jurors. Grand jury and the coroner's jury. Role players. Let's think of a couple more. There's a lot of them missing up there. Take a good look. Who can give me other people that play a part in the trial, but they're not listed up there?
Witnesses.
Yeah, witnesses. Look at that. Gotta have witnesses to call. Who else? I thought the list was a little more extensive. That's all I got. Think about it. Who else is involved in the trial process? What's that lady who sits in the front? Stenographer. Who else?
Bailiff.
The bailiff. Court recorder? Court clerk? Security? There's so many other people involved. You need to know these people. They're important. You gotta know who they are and what their role is. Stages of a trial. Before we watch that, there's different stages of a trial. We talked about motions, pre-trial motions, bail hearings, evidentiary hearings. If a witness has something to hide, but you need them to testify, they're going to have a hearing for immunity. Are we going to grant partial immunity? Don't know. They have separate hearings. Okay? So keep that in mind. There's a lot more than what this video tells you, but this is a good summation.
What happens when a criminal case goes to court? All criminal cases begin in district court. Less serious crimes or summary offences are tried in the district court. These cases are heard by a judge and more serious crimes are tried in circuit court and central criminal court. These cases are heard by a judge and jury, but it is the jury that decides whether the accused person is guilty or innocent. At the beginning of the court process, the accused person may plead guilty or not guilty. If they plead guilty, the judge sets a date when the person will be sentenced. If the accused pleads not guilty, the prosecution will call witnesses, which may include the victim, to give evidence to try to prove the accused is guilty. The defense solicitor can question the prosecution witnesses. This is called cross-examination. When the prosecution has finished questioning their witnesses, the defense team calls its own witnesses, which may or may not include the accused. The prosecution can cross-examine the defense witnesses as well. Once both sides have presented their case, it is then up to the judge or jury to decide if the accused is guilty or innocent. Guilt must be proven beyond a reasonable doubt. If the accused is found guilty, it is up to the judge to decide the sentence. A victim impact statement can be submitted before sentencing, either after the accused pleads guilty or is found guilty by a judge or jury. A victim impact statement is a written account in the victim's own words of the effect that the crime has had on him or her physically, psychologically, and/or financially. If you have any questions about this or anything else related to the criminal justice system, you can contact the Crime Victims Helpline.
Okay. We haven't talked about victim impact statements, so let's do that now. A victim impact statement is presented after a guilty finding, but before sentencing. Victims, let's talk homicide. Spouse was murdered during a home invasion. He's the bread earner, and the family relied on his income to sustain their livelihood. He's been murdered, trying to defend their property. The culprits are apprehended, brought to justice. They're found guilty. During the victim impact statement, wife gets up, talks to the judge, pleads her case, why this person should receive maximum allowed penalty, whether it's life without or death penalty. So she gets up there and pleads her case, crying, gets the kids up here, 12-year-old, 10-year-old, 8-year-old, they've lost their father. Relatives make their statement known to the judge. So they're pleading their case, pouring their heart out. How much of an effect do you believe that has on the actual sentencing?
No, not much.
May say it. Just said none. Mr. Faulkner, do you think that the judge actually pays attention?
I think if the judge already knows the guilt, they already have the sentence planned out, so it's just to get the witness out there, or the victim. So I don't think it plays any role.
Two say no. You're both right. Absolutely zero. And the judge, as far as whatever he wants to do, actually plays a minimal role. The deal's cut between the government and the defense attorney in chambers. They go to the back, they always talk about different things with the judge before they come out into the courtroom. Sit back there and talk about things. He's found guilty, so we're going to talk about sentencing. The defense attorney is going to tell the judge all the good things this person's done. The DA is going to say, oh no, this guy's a career criminal. Look at now, finally he's killed somebody. Do we want this person out there? They argue, they bicker, they heckle. They even call in favors. Remember last time I made a concession? This time I need a concession on your part. They're cutting deals back there, almost as if it's a used car they're trying to sell. That was the impression I got watching this. And really, I was appalled. I believe the victim had some kind of a say in the matter. In reality, zero, none. So the deal's cut. The judge listens to what these attorneys are saying, and then decides, I believe the defense attorney on this one. It was an accident. There's still hope. I believe there's a chance for this young person. So instead of giving them life without the possibility of parole, we're going to give them 25 with the possibility of parole. Still harsh. This is a 20-year-old person. 25 years with the possibility of parole means he could do maybe 12 to 15 go before the board, be out before he even serves 20. 37, 38 years old, and back on the street. You're the victim, you're the family. How are you gonna feel about that, knowing that the person that ruined your lives is gonna be back out on the street soon? Not good. You're gonna be pretty darn upset about it. But that's just the way it works. 0. Victim are the forgotten. And I think the text refers to them that way. They're the forgotten people when it comes to justice. The judge, he just wants to keep the cases moving, clear his court calendar. Of course they want justice, but they got other motivations. The district attorney's overworked. And they really do. They have too many cases. They just want to hurry up, get this one out of the way, and move on. The defense attorney's got a bunch of cases he's working on. Nobody really cares about the victim. They don't. That's the sad truth. There's stages. And I had to break up these slides because the publisher put them all on one slide, and it was just overwhelming. So this is the first part, critical stages. A crime has occurred. That triggers the event, the crime, the commission of a crime. We skipped investigation for some reason. Investigation usually comes after the crime. Whether it's reported or discovered, an investigation will ensue. We make the arrest via a warrant. So we got our warrant that we needed. We go in and we make our arrest. They go to the county jail for booking. And there's a process there that must be adhered. The prints, delicing. I mean, there's a lot of nasty things that go on during booking. The initial appearance. Usually, if it's a weekday, they'll go in the next morning. They're going to go in the next morning and be told why they're sitting in county jail. You've been arrested for your participation in the home invasion, robbery, subsequent murder. You're going to be held to answer. Bail will be discussed. After bail, whether it's denied or granted, and then you can do, let me back up a little bit. I started, I never finished, my doctorate degree. And you have to announce a title, a subject of what your dissertation is going to be about. I was going to do the revocation process, why inmates reoffend so much, the cycle, okay, the cycle of offenses. My second choice was bail. And I did a little research on just that one issue on bail, and it's so controversial. And if I had to do it again, I probably would go with bail, because there is hope there. For recidivism, there is no hope. These guys are going to keep offending and offending, and there's just no answer. But to bail, there is a solution. And this is what the controversy is about. Ms. Chooks, you're poor as dirt. You got no financial substance whatsoever. You're 0, maybe even homeless. And she committed an offense. We don't care why, but she went in and robbed a store. She did pretty good. Ended up taking a couple $1,000s in cash and some products out of the store. Luis goes into the store. Same offense, exact offense. But Luis is pretty darn rich. Comes from a wealthy family, good standing in the community. The offense is the same. The facts are the same. Should the bail be the same?
Yes.
Justice is blind, right? It's supposed to be the same. Over here, we're going to have bail set, I don't know, say $15,000. What's the likelihood of her getting $15,000? Homeless, not a nickel to her name? No. Come on. She's sitting in county jail, right? She's not going anywhere. This guy probably has $15,000 in his piggy bank. Is it going to bother this person at all to fork out $15,000? No. Not at all. He'll be back on the street within the hour because he's wealthy. She's going to sit in jail until her case is heard. That's the dilemma. Where's the justice in this? Remember, jail, being held in jail to answer for a crime, is not a punishment. It's not supposed to be a punishment because you're innocent till proven guilty. But in our system, it's turned into a punishment for the poor. And that is one of the areas they're looking at revising as we speak, because it's just not right. So jail is there to hold people accountable for their actions if they're flight risks. If there's a possibility these people will not stick around to make their court appearances, we hold them in jail. That's it. It's not a punishment. Charging decision complaint is filed. The grand jury files that decision via an indictment. The district attorney files it via information. You need to know those two ways to file criminal charges, because it will come up again. So the complaint, the charges are filed. Next, we get to the prelim. Okay, preliminary hearing. Judge determines whether there's probable cause to think an offense has been committed. Some of the outcomes: dismissal, present information, send the case to grand jury. Usually what happens in a prelim, it's not up there, but this is what happens. The two sides come together. The defendant's out on bail. They come to court, though, for their prelims. At prelims, a plea is entered. Guilty, not guilty. We're not guilty. Discovery is given. Reciprocity exists, so if the defense has anything, they have to give it to the prosecution. The state must present their case in chief. Why are we prosecuting this person? One official can provide all the testimony. It's called the 115 hearing. Usually the arresting officer will get up and they speak on behalf of all people involved in that allegation. That doesn't happen during the trial because that's called hearsay. But during the prelim, it's admissible. So the officer gets up there, recants the story of what happened and why this person should be held accountable. The judge decides. Do we move forward? Do we hold this person to answer? Does the state, in fact, have a case? If they don't, they dismiss it right there and then. Sometimes the defense feels compelled to present their argument, and they can. After the government gets done presenting their case, the judge will ask, do you wish to contest? And if they say yes, then they get their witnesses, and it's a little mini trial right there on the spot. Rarely does that happen. I think I only participated one time. And the judge found in favor of the government, and we still went to trial. But what that did is it showed our hand. Now the DA knows exactly what we're planning to do. And it better prepares them for the actual trial. That's why most of the times we're just there listening, finding exactly what they intend to do, and then I go out and investigate what the heck they're saying. And if I can contradict it, I tell the attorney, we can fight this one. We got a good chance, here it is. Then he'll decide with the client how they want to proceed. More than not, I come back and say, work a plea. They got this guy dead right. He's going up for whatever it is they want to give him. They got a solid case. No wiggle room. Then the attorney will try to meet and negotiate a plea. That all happens right here at the prelim. Very informative hearing. If you can meet at a courthouse around 10 o'clock, they go on every day. Okay, arraignment, standing mute, no contest on the plea or guilty plea. The arraignment is just the announcing again of the proceedings. Discovery, as I mentioned, is exchanged back and forth. That's called reciprocity. Each party has to negotiate the discovery, the evidence that they have, how they're going to get it to the other party. Pre-trial motions are filed. We want a hearing. Our client, the defendant, was insane at the time of the crime. we request a site eval be done. We have to present why, cite cases, and then the state gets to argue why it should not be done. That all happens at pre-trial. The plea negotiation comes in when the defendant feels they don't stand a chance in trial. Just give me the best deal possible. There's concessions being made for the admission of guilt, and when you plead guilty on the record, you're also waiving your right to appeal. So you can't go back later and, I want to appeal this. Nope, there is no going back. The state gives up certain things in favor of that plea, and that happens very often. The trial begins. The state goes first. They make what's called the opening statement. Why the jury should find this person guilty of the crime. They lay out their case. And everything that attorney is saying must be proven during the trial. So they can't just get up there and make a nice speech and not have any evidence to back it up. It must be backed up. So the state gets up, they make their opening statement. The defense gets a chance then. Do you wish to make an opening statement at this time? Or do you wish to reserve it for a later time? Most of the time they just go ahead and make their opening statement. Some attorneys don't like that, they'll hold back. They'll wait until, I like to call it halftime. Wait until the state finishes. They presented their case and they rest. Then the defense says, Your Honor, we'll make our opening statement at this time. Because now they got the ammunition, they can attack everything that the state just said. So it's usually beneficial to wait. Some defense attorneys don't want to. Either way, they make their opening statement. Then the defense puts on their evidence. If they're going to fight the case, it's called an affirmative defense. They have witnesses and they come in and they attack the issues as to why my client isn't guilty. Affirmative defense is one way to go. The other way to go is just to argue the case as the state's putting their witnesses in, one at a time. So Miguel gets up, takes a stand. The state asks him what happened. He says everything he wants to say, within reason. The defense gets up, cross-examines Miguel, because they don't have any witnesses of their own. So all they're trying to do is minimize the damage. That's just a defensive action. We have no affirmative action, we're just going to go defensive. That usually happens that way. Miguel can be excused, that means he's ready to leave, or he can be held, meaning you may be called on later. So stick around, we may need you. The state dismisses